Ladies and gentlemen, for those of you who are just entering the hall, as you will see, the hall is already set for the banquet, but the moot and the banquet are two separate events. Okay, so the moot is an open event. No one needs a ticket to come and see. We welcome everyone. But the banquet is a ticketed event. So at the conclusion of the moot, everyone will leave the hall. There was an area that you'll all move into, and then you'll come back in, but as you come back in, you will need to show your ticket. It's not possible to reserve seats for the banquet at this point in time, or indeed at all. You will need to take everything with you when you leave, okay? Thank you. Ladies and gentlemen, if I could ask you to take your seats, please, because we will be beginning very shortly. Ladies and gentlemen, please do take your seats because we will be beginning in about 1 minute.
Okay.
So,
Ladies and gentlemen, could you please take your seats very promptly as we are beginning? Ladies and gentlemen, welcome to the final hearing of the 33rd Willem C. VIS International Commercial Arbitration Moot. It's been a fantastic week and culminating now in this hearing. Before we begin, there are some short housekeeping announcements. As you will see, this room is set for the banquet, so it's very important that as you sit and listen to the moot, that you stay away from the glasses and the plates and the cutlery. We don't want broken glasses or noises coming from the audience during the hearing. At the conclusion of the hearing, everyone will be asked to leave the room. We will all need to leave the room, and there'll be some doors to the left that you do so. And I'll provide more instructions about that at the end. But it's not possible to reserve any seats for the banquet. You will need to take everything with you, particularly your ticket, because the banquet is a ticketed event. Ladies and gentlemen, let me introduce the final panel and the teams. This final is a hearing between the University of Münster as claimant and the University of Cambridge as respondent. A round of applause. Our presiding arbitrator today is Ms. Lucy Reid. Lucy is currently the president of the Singapore International Arbitration Centre Court, and she's an independent arbitrator based in New York, specialising in investor state and complex international commercial disputes. Lucy is recognised in Tier 1 of Chambers and Partners' Most In-Demand Arbitrators Global-Wide 2025. She's served as president of the International Council of Commercial Arbitration, ICA, and the American Society of International Law, and held positions at the National University of Singapore. To Lucy's left is Siegfried Elsing. Siegfried is a partner at Orrick, Harrington and Sutcliffe, and an arbitration practitioner with more than 40 years' experience in national and international proceedings. He's acted as counsel or arbitrator in more than 300 arbitrations, including ad hoc proceedings and arbitrations under the rules of most leading arbitral institutions. Siegfried regularly lectures and publishes on international arbitration and comparative law, and in particular teaches arbitration law at Heinrich Heine University Faculty of Law, Düsseldorf, where he's an honorary professor. To Lucy's right is Edgardo Munoz. Edgardo is a professor of law at Universidad Panamericana, Guadalajara, Mexico, and an experienced international arbitrator and counsel with a practice spanning multiple jurisdictions and legal traditions. Edgardo is a member of the CISG Advisory Council, the ITA Academic Council, the ICC World Commission on Arbitration and ADR, and the VIS Moot East Foundation, and serves as UNIDWA correspondent for Mexico. And Edgardo himself was a former participant in the 11th Willem C. VIS Moot. Ladies and gentlemen, without further ado, I hand over to our chair. Thank you.
thank you. Welcome to our hearing. I have 4 preliminary points. The first is, counsel, pay no attention to all the people in the room. We're here to listen to you 4. The second is, as in any real hearing, we have a quick disclosure from Dr. Elsing.
Ms. Bushkin, gentlemen, as is necessary for purposes of full transparency, I want to make a brief disclosure One of the party's representatives is the University of Münster. And as you can see from my white hair, it's a long time ago, but I attended Münster University Law School. In fact, I wrote my PhD there, and I have been lecturing there even, not recently. I want to make that disclosure. I feel impartial and independent in spite of my good memories of my alma mater. And I want to, as I say, in the interest of full transparency, make that disclosure.
Are there any objections?
None at all.
Not on our side.
Thank you.
Thank you.
Next, I would like to say that, Council, while we know that your original agreement was for a time allocation of 14 minutes, 1 minute, at the request of the tribunal, you've conferred we would like longer rebuttals and sir-rebuttals to allow you to address what each side has said and any questions from the tribunal. So it will be 2-minute rebuttals and 1.5-minute sir-rebuttals within the 15 minutes for each presentation. So thank you for your cooperation on that front. Third, before we start with your presentations, the tribunal, for guidance in where you will be taking us today, would like first the claimant, not to plead, but just in 30 seconds or so, to tell us what you see as the most significant issue to get you to a finding of liability and damages in this case. And then after that, for Respondent, what you see as the most significant defense to that. It can be either procedure or merits.
Madam Reed, the most significant issue leading to Respondent's liability in this case is the fact that there was an apparent risk to the contract's performance, and Respondent, despite being presented with 2 viable options to ensure this performance, did not take them and is therefore not exempt from liability. Thank you.
Thank you. Mr. Loki.
Thank you. We think that the core part of the dispute lies in the relationship between the contractual force majeure clause and Article 79 of the CISG and what requirements we should apply in determining if Respondent is exempt from liability. Thank you.
Thank you. Then we'll proceed to the presentations on the procedural points.
Members of the Tribunal, good afternoon. My name is Ewan Crease and I represent Respondent on the procedure. My co-counsel, Thomas Loke, will continue on the merits. Today, Claimant asks this tribunal to ignore obvious risk. First, they seek to impose the 2016 SIAC rules despite there being no such agreement between the parties, all in order to prevent disclosure of their third-party funding documents despite clear risk to Respondent's right to recovery and possible undue control on the part of their third-party funder. Against this backdrop, we will make 2 submissions. First, that under either the 2016 or 2025 SIAC rules, the Tribunal should order full disclosure of both the third-party funding document and the after-the-event insurance document. And second, that the Tribunal should apply the SIAC 2025 rules to these proceedings in line with the parties' contract. To clarify my order of submissions to the Tribunal, we submit the core procedural dispute as it stands today is that of disclosure. As we are submitting that disclosure is both available and warranted under either rule set, we will begin with disclosure, noting that the applicable rules are still important for any future procedural issues. Turning then to my first submission. We will first outline the threshold for disclosure under both rule sets. Under the 2025 rules, the matter is simple. Under Rule 38.4, the Tribunal may order disclosure in respect of third-party funding documents as it sees fit. There is no such explicit third-party funding power under the 2016 rules. However, there is a general production power under Rule 27F, and the Tribunal may order production of documents that are relevant and material, and as clarified by the 2017 SIAC practice note, either necessary or expedient. We will show how this threshold is met with regards to both agreements and therefore that disclosure must be granted.
This tribunal is most interested in why the disclosure is at issue here. We can accept that we have the authority under either set of the rules.
Madam Presiding Arbitrator, we will continue on that then. First taking the after the event insurance agreement covered by Litshaw. It was established in RSM and St. Lucia that a respondent's right to recovery must be made effective. If I could turn the tribunal to page 58 of the case file. This would be procedural order number 2. And if the tribunal is with me, specifically clarification 20, we would like to highlight 3 factors that increase the risk to respondent's right to recovery. First, that claimant likely cannot pursue this claim on its own 2 feet and is reliant on HEJ funding. Second, outlined in the second line, they have lost 15,000 orchids, which is over 2 years' worth of stock for them. And finally, further in the passage, that claimant, because of this loss, is likely only solvent until June 2026. All we ask the tribunal to infer from this is that respondent's right to recovery is contingent entirely on the effectiveness of the ATE insurance agreement. The mere disclosure and presence of this agreement is not adequate for 2 reasons. As highlighted both by the English High Court in Acertus and Lewis and the Federal Court of Australia in Peterson and Queensland Bank, there are 2 reasons why mere disclosure of the presence of the agreement is inadequate. First, the coverage may only be partial. Because claimant is not in a strong financial position, it is unlikely, in the event this tribunal did make an adverse costs award, they would be able to cover even partial of that adverse costs award.
But counsel, you have not yet asked for security for costs, so isn't this a premature concern of yours? I mean, they have third-party funding and they have ATE, which should be sufficient assurance for you, don't you think?
Madam Presiding Arbitrator, 2 points on this. First, although security for costs would be the standard procedure, on these specific facts, a security for cost application is likely to be ineffective. Claimant has lost over 2 years' worth of stock and is only solvent for 2 months. We submit it is unlikely that they have adequate assets that could be secured against, and therefore the ATE insurance agreement alone is the only path of recourse for respondent. Second of all, because of claimant's weak financial position, a security for cost application could tie up even more of their assets if they do exist, and would prevent claimant from running their business effectively. Instead, we simply ask for disclosure, and if the ATE insurance agreement is full coverage and does not contain the terms I will now expand on, this would be adequate for respondent's right to recovery.
Excuse me to interrupt, Counsel. In procedural order number 2, paragraph 20 that you just addresses to, there is also some elements that we may consider, and we would like to know your position on this. One of them is that claimant is not insolvent at this point. The other is the information that claimant has future contracts for the next 2 years. And added to that, if I understand your argument correctly, you are not requesting security for cost, and you are not planning to request security for cost. So why would be the goal, the advantage, the favor that you would obtain by watching what the insurance agreement says?
Mr. Co-Arbitrator, to take your question in 2 parts. First of all, although claimant is not insolvent yet, it is stated that there is a likelihood by June 2026 they could be. And if we were to make this request at that point, there is likely nothing this tribunal could order to secure respondent's right to recovery. On the second part of your question, on the fact that we do not request security for costs, that is pending the result of the ATE insurance document. If the ATE insurance document is either partial coverage or contains either termination rights or issues with assignment, then we would make a security for cost application. We have only held off on doing that, both because we do not believe it would be effective given the stance of the assets claimant holds, and we do not want to intrude on claimant unnecessarily.
Counsel, it nonetheless seems to me that you are somewhat engaging in a fishing expedition. It seems that perhaps the position you take now and your request is premature. Why didn't you make an application for security for cost in the first place? And then we would have to deal with that. We would have to see, and we could see what claimant's reaction is.
Mr. Co-Arbitrator, you raise a valid concern. However, again, we would like to iterate 2 points. First, the security of the costs may hinder claimants' ability to run the business in a way that would drive them out of proceedings, and we have no intention to do so. But second of all, this point is helpfully clarified in the case of Premier and PwC by the English High Court. Where a claimant is impecunious and has ATE insurance, that is grounds for disclosure of the ATE insurance document if the right to recovery is dependent on that document. If the claimant were to provide any other form of protection, then our request would be withdrawn. However, they have not, and we submit they cannot. Now moving on to the ATJ funding agreement. The primary concern here is undue control. If I could turn the tribunal to page 40 of the problem. This is Respondent Exhibit R4. If the tribunal is with me, in the second main body column, 3 factors are highlighted.
Counsel, I have a question on this exhibit that you put in R4. This is just a newspaper or a newsletter article saying that the funder is a rogue funder, charging high rates and being very aggressive. What's the evidentiary value of this document for this tribunal?
Madam Presiding Arbitrator is right to identify that this is simply an article, and we do not base our request solely on this article. We simply ask the tribunal to consider what was helpfully summed up by Madam Presiding Arbitrator, the fact that there is a chance this funder is an aggressive player in the market and has contracted with claimant in a weak financial position. This means claimant may not have had the negotiation power to reject any undue contractual leverage ATJ imposed upon them. Therefore, we do not ask the tribunal to infer this simply from the presence of a funder, which would go against Rule 38.5 of the 2025 rules, but instead to see in light of claimant's situation, there is a high risk here.
On that last point that you just raised, if we go to PO225, we notice that indeed the third-party funder has not agreed to an adverse cost coverage. But in the next paragraph, 26, we also know that he is not participating in the strategy and does not have a threshold imposed on claimant to accept any settlement. So probably we shouldn't be worried about that.
In the interest of time, I will quickly answer Mr. Co-Arbitrator's question, then move to my second submission. The main concern for respondent here is confidentiality. If ATJ has contracted with claimant that they must disclose any information they receive in these proceedings in order to keep an idea of the prospects of the case, this also is an undue control situation for claimant, where they have to choose between a breach of contract with ATJ financing, which they could not deny due to their weak negotiation position, between the confidentiality of these proceedings. Respondent must feel secure in disclosure in this tribunal that confidentiality will not be breached. Therefore, we request both documents. Moving then to the applicable rules. We have 2 simple arguments for the tribunal on this. First, that the default rule under Rule 1.5 of the 2025 SIAC rules stands and is not modified by the contract. And that rule is that the rules at the commencement of arbitration will be applied. Second, that the date of commencement stands as the date that the SIAC registrar received notice, 31st of July 2025. On to the first argument. If I could turn the tribunal to page 13 of the problem. Specifically, clause 15. If the tribunal is with me, there is only one material deviation from the SIAC model clause, notwithstanding the AMA protocol further on. This is that for the time being enforced has been removed and current has been inserted. We have 2 points on this. First, in 2004, the Singaporean Court of Appeal in Black and Veatch established that there is a prima facie assumption that the default rule will apply absent clear intention to derogate from this rule. and further clarified in the case of Car and Cars by the Singaporean High Court that general words are insufficient to identify a specific addition. Now, opposing counsel may argue that the negotiations between Claimant and Botanical Garden changed this meaning. However, the tribunal can see on page 10 of the issue that the parties, by mutual agreement, terminated the contract between Claimant and Botanical Garden. As I notice my time is elapsing, could I request an extra minute from the tribunal to conclude my submissions?
Yes, and please focus on why this matters beyond the disclosure of the funding documents.
Madam Presiding Arbitrator, we only have one core procedural dispute today, that of disclosure. However, going on, the parties may experience other procedural issues, and related to disclosure, the 2025 rules have wider powers, such as the case management conference power, which has already been utilised in this case, as well as wider powers to impose sanctions for non-disclosure. The rules that apply throughout these proceedings give the tribunal wider power under the 2025 rules, which is exactly what the parties agreed to when agreeing to the institutional development. Finally, on commencement. Opposing counsel will likely argue, due to the second main body paragraph of the dispute resolution clause, that the fact that mediation is the first step changes commencement of arbitration to the 19th of December 2024. However, this is not the case. Again, the tribunal is faced with a default rule, Rule 6.2, which states that the receipt of notice of the SIAC registrar is the commencement. There are no clear words derogating from this, and again, the default stands. Therefore, we request both documents for disclosure and submit the 2025 rules must be applied in line with the parties' agreement.
Thank you, counsel. One question. I understand your argument, but can you appreciate that the reason why counsel who are negotiating an arbitration clause would want the security of saying the rules currently in force will guide a future arbitration?
Madam Presiding Arbitrator, two short points on this. First, that is something the parties could have considered, but nowhere in the case is this explicitly stated. And second, Claimant cannot show a mutual agreement, either between Claimant and Botanical Garden, to fix these rules. In their own CEO's witness statement on page 8, paragraph 8, for reference for the tribunal, Ms. Georgia Threafastris states that the only concern for Claimant was that the clause meant arbitration was the final step, and at no point in the extensive witness statement is Botanical Garden's supposed intention to fix the rules commented upon.
Thank you, sir. Ms. Bushkin.
Thank you. Madam Presiding Arbitrator Reed, Honorable Tribunal, I will come closer to the microphone. My opposing counsel argued that disclosure of both the agreement between Claimant and Litsure should be disclosed, even absent a pending application for security for costs, not to unduly burden Claimant. We will show that the request for full disclosure does exactly that, unduly burden Claimant, and shows disregard for proportionality in this regard. Further, this issue is directly linked to the applicable rules in this arbitration. The parties in the arbitration agreement have agreed to the current rules in force at the time of contracting, namely the SIAC Rules 2016. Under this rule, the threshold for disclosure is narrower under the rule that opposing counsel is invoking now that it wants the disclosure of the agreements. In light of this, Claimant will be making two counter-submissions. First, we respectfully ask the tribunal to reject Respondent's disclosure request, and second, declare the SIAC Rules 2016 the applicable legal framework for this arbitration. On the threshold, Madam Presiding Arbitrator has already stated there is the general power for document production under both rules, and we agree. However, the legal threshold is a different one. Under Rule 27F, as my opposing counsel correctly stated, the question is the one of relevance and materiality. And the requested disclosure does not meet this threshold. However, even under the broader Rule 38.4 of the new SIAC Rules 2025, this tribunal should still not order disclosure. Opposing counsel quoted that the tribunal enjoys the discretion, and I quote, as it sees fit, quote end. However, what Rule 38.4 also states is that the tribunal should weigh the interest of the parties. And in this case, claimant's interest to not disclose the two entire agreements outweighs respondent interest in the information contained in these agreements.
Counsel, is your argument that it's irrelevant and immaterial for a respondent to know whether it would be able to collect on damages and on security for costs, on costs, under the 2016 formulation?
Absent a pending application for security for costs, indeed, as it was held in the case Spears & Johnson v. Make My Trip and Hotel Travel by a SIAC tribunal in 2017, because there is no legal consequence linked to the disclosure request at the present period of time. We will first address the agreement between claimant and Litschur, as my opposing counsel did, before moving on to the agreement between claimant and ATJ funding. As for the Litschur agreement, opposing counsel argued that it's right now not planning to even apply for security for costs, seeing that this agreement, if disclosed, could be ample security. Again, we note that absent this application, there is no relevance of the content of this agreement. And the disclosure of the agreement, as well as the disclosure of the ATJ funding agreement, would indeed place a burden on claimant, not like the application for security for costs would do. Why? The information contained in these agreements. For the funding agreement, contained would be claimant's entire arbitration budget, thereby its financial runway, and both agreements can be indicative of the funders and insurers' assessment of the merits of claimant's case. This information in the hands of opposing counsel would create a serious information asymmetry and thereby tilt the procedural balance in favor of respondent.
But, counsel, is there asymmetry without respondent having a sense of the content of your third-party funding agreement in terms of negotiations, potential settlement, given the risk that the cost, the premium, could be at issue in an award on costs? That's what Spears & Johnson was about.
Are you referring to the agreement with Litschur or ATJ funding regarding this question, Madam Presiding Arbitrator?
I couldn't hear you, sorry.
Excuse me.
You have to come closer to them. You have all this.
Yes.
I'm referring, my question is back to relevance in terms of symmetry of information on the funding arrangements in an important case such as this between claimant and respondent.
For the symmetry of information, claimant does not have the relevant information on sides of respondent as for financial capacity regarding that they are also financially supported by their parent company. However, we are not requesting this disclosure, and neither should opposing counsel regarding that there is never 100% certainty as to the solvency of one party. Mr. Arbitrator already touched upon the fact that the insolvency projected is only a likelihood. And in the case Escosol v. Italy, decided by an ICSID tribunal in 2017, the tribunal rejected a request for security for costs, as well as a request for wholesale disclosure, seeing that the indeed insolvent claimant had obtained an insurance policy. While we note that in this case the tribunal was, by a voluntary disclosure, already aware of the amount of insurance, this was made after the pending application for security for costs, and in such a case, our client would be willing to disclose the insured amount to the eyes of the tribunal only, who is the tribunal deciding upon the request for security for costs. Now, regarding the agreement between claimant and ATJ funding, opposing counsel stated, and I quote, "The primary concern is undue control." And I would again like to invite the tribunal to page 40 of the record, Respondent Exhibit R4, and as Madam Reed correctly noted, a newsletter. In the right column, in the lower part, it states, and I will read, starting with "he warned." Quote, he warned against drawing any broader conclusions from the funding agreement disclosed or considering the decision to be indicative for future cases. The only source opposing counsel is basing their argument of this rough reputation on is a singular news article, a singular case, which factual matrix is unknown to either party and the tribunal, and the spokesperson himself warns against drawing such a conclusion. Against this background, and considering that also regarding the negotiations powers invoked by my opposing counsel, we would like to note that the agreement with ATJ funding was indeed concluded in February before the financial difficulties arose for our client. Against this background, there is no legal basis that would justify respondents' interest in this agreement that could in any way outweigh our client's interest not to proactively disclose sensitive commercial and financial terms to the opposing party, possibly creating serious settlement leverage on sides of respondent. If I can be of no further assistance on the question of disclosure, we would now move to claimant's second submission and why the SIAC Rules 2016 are the applicable legal framework in this arbitration. We would like to start by noting where we can...
To interrupt.
Yes.
If I may ask you to address the same question asked by the chair, what would be the implications of having one or the other rules applicable? And in particular, opposing counsel has raised the idea or the argument that it's better to fix the rules now because later on may be other procedural issues that may have different treatment according to the set of rules. What is your position on this, and whether in applying any of the rules we risk also the validity of the war?
Could you rephrase the latter part of your questions, as
Yes,
I could not
hear
hear
later
it?
question is, if we make a wrong decision, if we interpret the agreement in favor of one of the parties, or if we interpret it in favor of the other party, is there any risk with the award with regards to its validity? And what would be the ground for this?
And while you're answering questions, this tribunal is very curious. We need you to explain how an arbitration can be started without a notice of arbitration.
Yes.
Under the SIC rules 3.3.
Indeed. I will answer your questions in the order they were posed. Mr. Arbitrator, the reason for invoking the agreement to the SIAC Rules 2016, which was invoked in the notice of arbitration and before the disclosure request, is that the parties have autonomously agreed on the current rules. And according to the principle of party autonomy, the tribunal should uphold this agreement. Now, as for the enforceability of an award, we are not of the position that either decision of the tribunal would pose a risk to the enforceability in line with the principle of minimal curial intervention if the tribunal would interpret the phrase current. Now, regarding the mediation, while it is usually the notice of arbitration that commences arbitration, this can also, by virtue of party autonomy, be alterated by the parties' agreement. And this is what they have done in the present case, altering the ARB-Med-ARB procedure to ensure an enforceable award under the New York Convention for the case that the parties would successfully settle in mediation. That this is a possibility is also, that the deviation of the commencement date is a possibility, is also enshrined in Article 21 of the Danubian Arbitration Law. However, as the first point we would like to base this argument on is the word current and the agreement, we will focus on this. We agree with the opposing party that there is generally a presumption, and we agree that the wording in the clause is current. This needs to be interpreted pursuant to Article 8, subsection 2 and subsection 3 of the CISG. How would a reasonable person in the same position as claimant and respondent, with knowledge of all relevant circumstances, including negotiations, understand the phrase current? Opposing counsel quoted case law to substantiate and elaborate on the established presumption. We would like to note that neither in the case Black & Veatch v. Jurong Engineering, nor in the case Car and Cars, was the wording of the model clause current. Instead, in the case Car and Cars, the court and tribunal interpreted the model clause of the SIAC, well established to refer to the rules in force at the time of commencement of arbitration. Now here in this case, there is not only the omission of the phrase "for the time being in force," but the deliberate substitution with the phrase current. Current
Counsel,
meaning...
I have to interrupt to say this tribunal is very happy to run this arbitration under either the 2016 rules or the 2025 rules, unless you can tell us that there is a dispositive outcome affected impact of the choice of one or the other.
Indeed, the tribunal should run this case under the SIAC Rules 2016, upholding the parties' agreement by deviating from the model clause and expressing the objective ascertainable intent to fix a static reference to the rules in force at the date of contracting.
Excuse me, Counsel, it seems you are avoiding the question. The question, if I may, Madam Chair, was really what is the relevance of the distinction that you make between the 2016 and 2025 rules? We want to be efficient. We don't want to deal with issues which are theoretical. What is, at the end of the day, the difference?
As I note that my time is elapsing, I will quickly answer your question and then conclude our submission. We would also like to conduct efficient proceedings, and these proceedings have commenced under the SIAC Rules 2016, as the registrar has determined these rules applicable pursuant to the Notice of Arbitration. We deem that it would not be efficient to now change the rules mid-proceedings, and we again want to reiterate that the threshold for disclosure under the SIAC Rules 2016 is indeed narrower, and our client does not want to disclose the two funding agreements for very good reason. Against this background, we respectfully ask the tribunal to keep administering this arbitration pursuant to the SIAC Rules 2016 and reject respondent's disclosure request. Thank you very much.
Thank you, Ms. Bushkin. Mr. Kreis. We look forward to your rebuttal. We've put some complicated questions out there for you both.
Members of the tribunal, I will address first the points made on disclosure, then the applicable rules. First, starting with the ATE insurance agreement. Opposing counsel rightly states that the tribunal must weigh the interests of the parties. It does not explain in a single manner how respondents' right to recovery should be protected, bar simply stating security for costs should be applied, but provides no assertions as to the assets that could be secured, or no evidence that this would be an effective application.
What about her argument that they don't know whether your parent will pay costs as well? What's the difference in terms of insecurity?
Madam Presiding Arbitrator, this is merely deflection. At no point in the case file has claimant asked for disclosure, and respondent has never stated it is not open to disclosure. Obviously, I would have to confirm with my client, but there is no evidence that respondent is not, for equality of arms reasons, open to disclosure. On the ATJ funding agreement, opposing counsel cites information asymmetry, but as rightly identified by Madam Presiding Arbitrator, respondent should not be expected to go on in these proceedings having no protection on their right to recovery. Further, opposing counsel states our only evidence is the article, yet crucially fails to engage with their own financial position. They are almost insolvent, have lost over 2 years' worth of stock, and so any arguments on information asymmetry, when balanced against respondents' crippled right to recovery, has to tilt in respondents' favour. Finally, on the applicable rules, one crucial fall down of their argument. We stated no mutual agreement between Botanical Garden and claimant could be shown. At no point did counsel show that there was mutual agreement. They simply seek to change the agreement for what they perceive to be a more advantageous position on disclosure. Thank you.
Thank you. One last question. Neither side has really addressed the most common worry about disclosure of the details of a third-party funding agreement, and that is that it may reflect a funder's litigation risk assessment in terms of the strength of their case. What is your position on that? Won't that help you?
Madam Presiding Arbitrator, that could theoretically be used by a respondent to lengthen proceedings or make a claim based on that information. However, this tribunal does have the power to both order that we cannot base any further claim on that information, and second, through their case management powers, prevent respondent from that very manipulation. If
That's not our concern about your lengthening the litigation. It's the impact on the tribunal of knowing what the funder might think about the merits of their case. How should we be assessing that? That's our concern.
Madam Presiding Arbitrator, I see your concern now. The tribunal does have the power to use expert witnesses or experts on evidence. If the tribunal is concerned that they will be prejudiced by the merits of the case in the funding agreements, they could simply order disclosure to both respondent and a third-party expert witness who can inform them of any issues in the agreements without prejudicing the tribunal.
Thank you.
Counsel, before you conclude, with the kind permission of Madam Chair, if we were inclined to grant your request, what do we make of the fact that your clients seem to also receive funding from the parent company? It doesn't create an imbalance, an element of unfairness? What do you make of this fact?
Mr. Co-Arbitrator, 2 short points. First, we would distinguish on the parties' situation. Equality of arms does not require equal treatment in absolute, simply equal treatment in the situation. Respondent does not have the same financial impecuniosity or possible undue control outside the relationship of a parent company, which is everyday business, and therefore disclosure is not warranted. However, second, if equality of arms is the thing this case hinges on, we will refer to our client and they will likely accept mutual disclosure.
I'd like to hear from Claimant on this point as well.
Sir-rebuttal. Thank you.
Madam Presiding Arbitrator, Honorable Tribunal. My opposing counsel has again linked the necessity of the disclosure to its right to recover if it were successful in this arbitration. However, the only evidence for the control is the newspaper article, and opposing counsel has not linked ATJ funding to the recoverability of costs. Instead, however, it states that security for cost application would be ineffective due to claimant's financial situation. However, claimant has contracted with ATJ funding to remove the cost risk, also the cost risk for security for cost, from its balance sheets. So this application would indeed be effective one if the tribunal would order security for costs, which however is not necessary in the present case due to the presence of a reputable adverse costs insurer. Now on the tribunal's questions. Indeed, both agreements may reflect the risk assessment of the funder and the insurer, 2 separate assessments made regarding claimant's chance to succeed on the merits of this case. This information could prejudice the tribunal and could prejudice the tribunal to the disadvantage of respondent, a reason why tribunals have held that they are not interested to have this disclosure issued to the tribunal. I see that my time for sir-rebuttal is elapsing. I will still quickly address Professor Elsing's question for the parent company funding. Indeed, it would establish an unequal treatment, ordering disclosure for claimant of its entire financial situation and funding, however, having no certainty to the financial capacities of respondent and their parent company. However, we want to stress that we are not disclosing, we are not ordering disclosure of, we are not requesting disclosure of respondent in this regard, and are relying on the fact that ATJ funding, however, grants claimant crucial access to justice to bring its claim in front of the tribunal, and this should be considered. Thank you very much.
Thank you, Ms. Buschke. Now we'll move to the merits with Mr. Pringer-Berenkopf.
Thank you, Madam Reid, members of the tribunal. Let me start by quoting opposing counsel on the procedural issues. In his introduction, he stated that claimant, and I quote, asked this tribunal to ignore obvious risks. In this case, it was actually Respondent who ignored obvious risks despite Claimant repeatedly asking Respondent not to do so. When Respondent then informed Claimant that it could not take delivery of the vanilla orchids in time, Claimant resold these orchids in an effort to mitigate losses. And this leads me to Claimant's two submissions today. First, Respondent's liability is not exempt pursuant to Article 79 CISG. And second, the tribunal should award Claimant $3.3 million as damages pursuant to Article 75 CISG. Starting with Claimant's first submission. Clause 4.1 and 5.1 of the sales agreement impose on Respondent the obligation to obtain all relevant import permits. After a subsequent uplisting of the vanilla orchid into CITES Appendix 1, this...
I want to stop you there. Sorry for that. Yes, indeed, that clause says that all import permits are the obligation of Respondent, but this particular import permit didn't exist at the time. I understand that your position is basically that all import permits, even if they are not imposed at the time, are on the risk of the Respondent?
Professor Munoz, it is not Claimant's position that all import permits are within the risk of Respondent. It is our position that Respondent was obligated to obtain them, and when they failed to do so, they breached the contract. Now, the CISG generally holds breaching parties strictly liable for their breach and only exempts them in certain exceptional cases. Members of the tribunal...
Now that you went to Article 79 directly, why don't we just look at Clause 12 in the contract?
Professor Munoz, opposing counsel on the merits, in his quick introduction has already invoked the force majeure clause, and I invite the tribunal to follow me to page 13 of the record, which evidences this force majeure clause. Now, while parties are in principle free to derogate from any of the CISG's provisions pursuant to Article 6 CISG, force majeure clauses are often only supplementary in nature. And in this regard, Clause 12 has an effect. It specifies the first requirement of Article 79, Section 1 CISG. It also specifies the notification requirement of Article 79, Section 4 CISG. Further, it imposes on the affected party an additional obligation to mitigate effects even when affected by a force majeure event. What Clause 12 does not do is exclude any of Article 79's requirements, meaning uncontrollability, unforeseeability, and unavoidability.
So your position is that because it's not complete as Article 79, there was no derogation?
This is our position, Professor Munoz, and the reason for that is that force majeure under the CISG is considered an exceptional excuse to strict liability. If we were to find that parties by mere omission of certain requirements could exclude essential requirements to this excuse, meaning unforeseeability and unavoidability, this would diminish the force majeure excuse to an unacceptably low standard. This clause does not show an intent of the parties to exclude any of the requirements of Article 79.
Counsel, what about Article 35(2) of the SIC rules, which says the tribunal shall make decisions in accordance with the terms of the contract?
Madam Reed, the tribunal shall make decisions in accordance with the terms of the contract. However, the contract must be interpreted pursuant to Article 8 CISG. And under Article 8 CISG, as the force majeure clause was not discussed, we should look to the understanding of a reasonable person. And a reasonable person would not understand the omission of the unavoidability requirement to give Respondent or any party the right to sit on their own hands for 5 months, doing nothing when faced with the risk of an impediment. Therefore, opposing counsel will have to prove that it could not have avoided this impediment, and they will fail to do so. This is now regarding the third requirement of Article 79, that of unavoidability.
And which impediment should we be looking at? Which specific impediment?
The impediment the tribunal should be looking at, Madam Reed, is the uplisting of the vanilla orchid into CITES Appendix 1, which made import permits a necessity, and these import permits are not granted for commercial purposes under CITES Appendix 1. Now, Respondent, in their own response to notice of arbitration, acknowledged that the vanilla orchids, and I quote, were obviously purchased for primarily commercial purposes and thus not eligible for an import permit. There were clear warning signs that this uplisting would take place, and Respondent ignored them. In September of 2023, the Standing Committee to CITES proposed to uplist the vanilla orchid into CITES Appendix 1. As I stated, under CITES Appendix 1, import was prohibited for primarily commercial purposes. And at the last conference of the parties in 2022, out of 51 proposed changes to the appendices, 44 got adopted, being 80% of proposals. Respondent had to see the apparent risk to performance posed by this proposal. Nevertheless, Respondent stayed inactive. Claimant, on the other hand, took a more realistic view of the matter and proposed two measures: either apply for an anticipatory permit or bring forward the delivery date. Now, while an anticipatory permit likely at virtually no additional cost would have ensured the performance of the contract, in the interest of time, Claimant submissions will focus on the possibility of bringing forward the delivery date. In this regard, Respondent refused this measure on the grounds that it would have entailed unreasonable cost. Now I want to invite the tribunal to take a step back and see the bigger picture here. Non-performance of the sales agreement put the entire contract volume of $6.6 million at risk. In the case file, Respondent reliably can only point to the increase in transportation costs, which would have resulted in a mere 2.5% increase of the overall contract volume.
Before you continue, two questions. What is the threshold we should be looking at to assess whether it became excessively onerous? And second question is, they had a right to late delivery. I mean, they had a right to, according to the contract, or to receive the goods in March 31. And I wanna see what is your client's positions on this and how it fits with your arguments.
And a third question is, beyond costs, what about the orchids themselves, the environmental impact, the risks that they would lose up to 30% of these endangered orchids with an early acceptance?
I will address the questions in the order they were asked. Regarding Professor Munoz's first question, you stated excessively onerous. This would refer to the hardship standard. Claimant is not relying on the hardship standard. Hardship refers to situations where the cost increase is a certain necessity to allow for performance. We are talking about precautionary measures. The tribunal should apply the reasonability standard of Article 79. However, this reasonability still requires Respondent to prove that bringing forward the delivery date was not reasonable. Regarding the second question, yes, Respondent did have the right to determine the precise date of delivery. However, it is within the very nature of situations of hardship that contracts must be adapted to the change in circumstances, that the parties must explore alternative avenues of performance when it becomes apparent that the first avenue is not available. And now regarding the question of Madam Reed. Yes, there was risk to orchids in case of an earlier delivery, and the reason for that is that only one of Respondent's new greenhouses had finished construction. Respondent in this regard had two options. Either store the orchids outside, which would have risked total loss of orchids under adverse weather. Claimant is not requesting this of Respondent. Respondent could have equally stored the orchids in its existing greenhouses, meaning that energy costs would have tripled and the natural losses of orchids could have doubled. However, Respondent cannot provide a base value for those relative increases, making it impossible to calculate the actual increase in cost. Energy costs could have tripled from $1,000 to $3,000. Compared to the overall contract volume of 6.6 million, this increase would still be insignificant.
What about the possibility to suffer a boycott in their own brand, and that this may lead to further damages to the reputation?
Could you repeat the question, maybe?
Yes, I understand from the facts of the case that there were some NGOs that started to demonstrate about the fact that that Respondent was about to import the goods and sell them for commercial purposes. Should we consider that fact, that there may be social boycott if respondent takes over the goods?
The tribunal should not consider this fact for two reasons. First of all, the contract states in clause 9.2 that losses arising out of reputational damage should not be considered under the contract. And second, it is on respondent to prove that it could not reasonably have avoided this impediment, and the vague pointing to reputational damage cannot suffice for this burden of proof. Respondent is therefore not exempt from liability, as it had two viable options to ensure the contract's performance. Now,
before you move on, I'm struggling with one of the excuses which you have not touched upon. What do you make of the fact that there was an unexpected deviation from the 90 days transition period? Normally, one would have expected that there were 90 days and that would have allowed some leeway, some time, and apparently that was deviated from for the very first time.
Professor Elsing, respondent could have known that this would happen, and respondent did know that this could happen. The abandonment of the 90-day grace period and the uplisting with immediate effect was proposed by the CITES Standing Committee, and Mr. Albius in his witness statement acknowledges this fact and says that he was surprised about the recommendation. However, the recommendation was still the recommendation. Now, moving to the second submission, the tribunal should calculate damages based on Article 75 CISG. Article 75 CISG allows a party to claim as damages the difference between a breached contract and a substitute transaction. If a seller is the aggrieved party, as in this case, the substitute transaction is the sale of goods originally allocated to the other contract. And claimant had allocated 3,300 vanilla orchids flowering in 2024 to the contract. Claimant resold those exact orchids to Herbal Cosmetics on the 15th of February 2024. Now, while it is true that Article 75 generally requires avoidance of the contract prior to engaging in a substitute transaction, case law shows, such as Kaplan v. Schnitzer, that there is an exception to this requirement in cases where the other party has refused to perform the contract. Now, may I ask for an additional minute to demonstrate this point, and then...
Yes, and the tribunal is concerned about the fact that you had your resale lined up before you told the other side you were terminating.
Madam Reed, in this case, I want to read from page 33 of the record. In light of time, the tribunal does not have to follow me. I will just quote, Mr. Albius on February 10th informed claimant that in light of the change in circumstances, it could definitely not provide the required import permit for the anticipated delivery date, and that it was also unlikely that delivery could be possible at all. Now, time was of the essence under the contract, and this was because the vanilla orchids were due to flower soon after, meaning that they would lose 30% of their value. It was essential that they be delivered before mid-May, and in an effort to avoid the 30% value decrease and mitigate further losses, claimant reasonably resold the orchids after Mr. Albius made that statement. The tribunal should therefore consider this sale as a substitute transaction under Article 75 CISG. Thank you.
Thank you, counsel. Mr. Lok.
Thank you, Madam Presiding Arbitrator. Members of the tribunal, good afternoon. My name is Thomas Luk Jehan, and I'm representing respondent on the merits of this case. Opposing counsel began by stating that respondent was ignorant, but is now claimant that ignores the parties' agreement and the CISG. Opposing counsel has argued that Clause 12 does not change Article 79 of the CISG, but as Madam Presiding Arbitrator pointed out, this neglects what the parties have explicitly agreed to. But opposing counsel then contends that under Article 75 of the CISG, there's an exception to the avoidance requirement when the other party refuses to perform. But that is not what Article 75 of the CISG says. This is precisely claimant's method. On procedure, they wanted to play by their own rules, not the rules of this arbitration. And now, They want to claim damages on their own terms, not the terms of the contract or the CISG. Against this background, I will make two submissions on the merits. First, Respondent is not liable for its breach under either Clause 12 or Article 79. And second, in the event that Respondent is found to be liable, Claimant is not entitled to $3.3 million in damages. On to the first submission, the Respondent is not liable. On the 8th of February 2024, Equatoriana introduced a ban on commercial imports of the vanilla orchid. This was an impediment beyond Respondent's control under Article 79, or a force majeure event under Clause 12 of the contract. Before we move on to the formal requirements of either provision, we would like to make two vital clarifications. First, what is the impediment we are talking about today? The impediment is not the uplisting of the orchid onto Appendix 1 on the 1st of February, but rather Equatoriana's sudden change position on the 8th of February, where it made a U-turn on its usual permit granting policy. Our second clarification, what is the relationship between Clause 12 and Article 79 of the CISG? We agree with opposing counsel's statement that they are supplementary, but we submit that opposing counsel fails to draw this relationship to its natural conclusion. If I could turn the tribunal to page 13 of the case file, where the force majeure clause is located. Under Clause 12.1, it is clear that a party is not liable for failure or delay caused by events beyond its reasonable control, including but not limited to acts of God, and so on and so forth. Note the phrase, including but not limited to. This force majeure clause is non-exhaustive, and as made clear by the Court of Appeal in Chile in the Van Wichenen case, such a non-exhaustive force majeure clause supplements Article 79. There's no intent to restrict the circumstances where force majeure is available. Rather, it shows when the parties have deemed certain circumstances to be automatically exonerating.
Counsel, when was it absolutely clear that you couldn't import the orchids?
It was only clear.
You applied for an import permit and you withdrew your application for an import permit. What should the tribunal make of that decision on your client's behalf?
Thank you. I'll answer that question in two parts. First, when did the impediment become clear? Our submission is that since the impediment that we have identified was on the 8th of February, that is the date the impediment indeed became clear, because no one, not even Claimant, expected Equatoriana to change its usual permit granting policy. The second point. Sorry, Madam Presiding Officer, may you clarify your second point again?
Just when was it definite that the transaction could not be fulfilled?
Indeed, and that was on the 8th of February, Madam Presiding Arbitrator.
Despite your having not had a rejection of your application for import permit?
Thank you, Madam Presiding Arbitrator. I remember the second point now, which is when did Respondent withdraw the permit? It is clear that when Respondent applied for the permit on the 5th of February, on the 14th, Equatorian authorities returned to Respondent and told them that no further permits would be issued pending ministerial guidance. However, Respondent kept the permit application in abeyance until Claimant finally terminated the contract on the 1st of March.
Thank you.
Therefore, our submission is that the force majeure clause and Article 79 coexist in parallel. If the tribunal finds that the Respondent has fulfilled all of the requirements under Clause 12, then we need not look no further. However, Article 79 can also apply, and it is relevant to this dispute. So no matter which provision the tribunal applies, our submission is that all roads do indeed lead to Rome, and that Respondent is exempt from liability. We will demonstrate now. Firstly, on Clause 12, it's stated here that if it falls within the list of events under Clause 12.1.
Mr. Luke, if we focus on the last requirement of 79, to be more precise, the possibility to overcome the impediment, I would like that you clarify to the tribunal whether what is the standard we apply, whether this is, as I asked already, hardship or impossibility, and then you develop further whether you reach that standard.
Indeed. Just to clarify before answering Mr. Arbitrator's question, that our central submission is that This impediment was a government measure within clause 12.1, and so respondent is not liable. But assuming that that is not accepted by this tribunal, and we now move on to the Article 79 requirements, as Mr. Co-Arbitrator pointed out on avoidability. The threshold under Article 79, is it reasonable to expect respondent to have avoided the impediment? There are two parts to this test. First, respondent must have actually been able to avoid the impediment had it applied for an anticipatory permit or arranged for earlier delivery. Second, even if it was possible to avoid the impediment, it must have been reasonable in the circumstances for respondent to do so. We will now tackle the two alternatives proposed by opposing counsel. First, on the anticipatory permit. Our submission is that such an anticipatory permit fails at the very first hurdle. It would not have changed the outcome. If I could turn the tribunal to page 4 of the case file, this is claimant's very own notice of arbitration. On paragraph 12, the third line, the first sentence there. In a comparable case of a looming inclusion into Appendix 1, which Equatoriana did not support, its authorities had adopted such an approach of an anticipatory grant of permits. Note two key facts. First, this has only happened once. Second, its authorities only adopted such an approach when Equatoriana did not support the inclusion of the orchid into Appendix 1. But members of the tribunal, on the 8th of February, Equatoriana changed its position, and it now indeed did support the orchid's inclusion in Appendix 1. It would have not extended such a limited and not well-known exception to respondent. Therefore, this does not change that the impediment was unavoidable. But then moving on to earlier delivery, which I suspect Mr. Co-Arbitrator is more interested in. Opposing counsel's submission is that the recommendation in September 2023 put the entire contract at risk. In their own words, respondents should have stepped back and saw the bigger picture. But we can level the same accusation to opposing counsel, because if we step back and look at the bigger picture, it was clear that if the impediment was the 8th of February change in position by Equatoriana, a standing committee recommendation to uplist the orchid has no relation to Equatoriana's usual permit granting policy. Therefore, our submission is that respondent in November 2023 was faced with two choices. On the one hand, there was no indication that Equatoriana would indeed change its position. Performance was possible. On the other hand, if respondent did accept earlier delivery, we concede that 1/3 of the orchids would have been safely stored at its specialized greenhouses, but the remaining 2/3 of the orchids would be at risk. This is because if respondent did indeed store the orchids in its old greenhouses, this could amount to a total of 40% loss, as made clear in Procedural Order, paragraph 15. Furthermore, this does not even include transportation costs, energy costs, and reputational losses that Mr. Co-Arbitrator had identified. Therefore, our submission is that it was the safest choice for respondent to refuse earlier delivery. Crucially, reasonableness, as explained in the Macromex and Globex International case and the steel bars case decided by the ICC, in both such cases, reasonableness is assessed according to the circumstances at the time of November 2023. Professor Brunner also elaborates that a party is not expected to take risks beyond what is necessary and not take precautions beyond what is proportionate to the risk.
Suggest you move on to damages.
Thank you, Madam Presiding Arbitrator. Assuming that the tribunal is satisfied on my submissions on exemption under either Clause 12 or Article 79, I'll now move on to the second issue. Claimant does not merely deny the application of Article 79, but rather tries to extract profits from respondent by claiming damages for losses it did not truly suffer. The main submission is that they've concluded a substitute transaction on the 15th of February within the definition of Article 75 of the CISG. But they get their calculation wrong on two fronts. Firstly, on price, and second, on quantity. Firstly, on price. Opposing counsel has already conceded that avoidance happened on the 1st of March. If I could turn the tribunal to page 39 of the case file. This is an email from claimant CEO to respondent on the 1st of March. In the second main body paragraph, the last sentence, claimant CEO declares the termination of the contract. This is a notice of avoidance under Article 26 of the CISG. However, avoidance happened 2 weeks after the substitute transaction on the 15th of February. Now, opposing counsel relies on the unsaid exception in the CISG, that when a party refuses to perform, the counterparty can simply waive away the requirement to avoid the contract. But the CISG is not a riddle to be solved. It aims for clarity and certainty, and opposing counsel submissions defies this central goal of the CISG. In fact, the exact situation that opposing counsel relies on, a refusal to perform, has already been catered for under the express terms of the CISG.
To understand your argument correctly, are you saying that claimant should have sold the goods later on?
We have two submissions on this point, Mr. Co-Arbitrator. First, yes, claimant could have sold later on. And second, even if they wanted to sell on the 15th of February, all that was required was to send one single email to respondent, as is made clear in Respondent Exhibit R3.
Yeah, is it important for your argument that the price didn't change until October? So probably a sale later on would have give us the same amount of damages, is it?
Indeed, Mr. Co-Arbitrator, we do find that problematic. However, we note that Article 75 had three cumulative requirements: that it needs to be after avoidance, it needs to have a reasonable time and reasonable manner, and must fulfill a party's expectation interests. Opposing counsel must prove all three, so as long as we tackle the avoidance requirement, Article 75 is not available. But we do also submit that claimant should indeed have waited for the price of the orchids to rise, as he eventually did later on. But moving back to my submission on avoidance and the timing, our submission is that under the CISG, Article 72, Paragraph 3, a declaration of non-performance entitles a party to immediate avoidance. A declaration of non-performance is synonymous with a refusal to perform. Our submission is that the CISG has already said its piece. There is avoidance immediately, not a dispense with the need to avoid the contract. And therefore, Article 75 is unavailable to opposing counsel. But finally, on quantity. Our submission is that 2,700 orchids should be used to calculate damages because respondent had the right to control the number of orchids it accepted. The reason for that is that it's because it was responsible for transportation. Therefore, it could choose however many orchids it wanted to accept aboard its transportation carriers. Therefore, we ask the tribunal to declare respondent not liable and also claimant not entitled to 3.3 million in damages. Thank you.
Thank you, counsel. Rebuttal, sir.
Thank you, Madam Reid. On the issue of the relationship between Clause 12 and the CISG, opposing counsel accused claimant of submitting that Clause 12 does not change the CISG. This was not claimant's submission. Claimant submitted that requirements are specified and an additional obligation is imposed. Claimant did not argue that it has no effect at all. Now, regarding opposing counsel's alleged effect of the force majeure clause, opposing counsel stated that once a party can point to any of the non-exhaustive list, any of the examples in the non-exhaustive list of the force majeure clause, it concludes in an automatic exoneration. This is not the purpose of force majeure. It does not give a party the right to look at an impediment in the face with reasonable measures to avoid it and still do nothing. Now, regarding these measures, pursuant to the anticipatory permit, my opposing counsel stated this would not have changed the outcome. We don't know if it would have changed the outcome because respondent never applied. And to the calculation of damages, my opposing counsel accused claimant of trying to extract profits from respondent and argued that claimant should have waited for the price to rise. In this regard, it was a certainty that the value would be decreased by at least 30%. So opposing counsel expects claimant to speculate for the market to rise to compensate for a certain 30% cost increase. This is not reasonable. Claimant, in an effort to mitigate damages, resold the vanilla orchids as soon as it was clear that respondent would not perform in time. Thank you.
Thank you. Sir-rebuttal.
Thank you, Madam Presiding Arbitrator. First, on the argument on Clause 12. Their submission is that they never argued that Clause 12 had no effect at all on Article 79. But again, what is the natural legal conclusion of this? Our submissions fill in the blanks for the tribunal. Clause 12 identifies specific circumstances for which the parties deem to be exonerating. The reason why Clause 12 is more relaxed than the Article 79 requirements is because, crucially, the parties were dealing with perishable goods. They knew that if a government measure, for instance, came into effect and prevented performance, prevented delivery within the allotted time period, this would hurt the goods. And therefore, the parties specifically contracted for Clause 12. By ignoring Clause 12, opposing counsel ignores the parties' agreement, as they've also done on the procedural issues today. Second, on the anticipatory permit, opposing counsel contests that the anticipatory permit could have still changed the outcome and that we do not know whether it would have. But our submission is that we do know based on how events unfolded. The reason why Ikutirana changed his position is because a social media campaign primarily targeted a respondent and convinced the government to uphold the CITES obligations to impose an import permit requirement. If, for instance, it granted an anticipatory permit but did not revoke it after the 8th of February, this would do nothing to soothe the rage of the last orchid. Finally, opposing counsel's only defense to Article 75 is that it was reasonable for claimant to resell the orchids at that low price, but they still skirt the main issue, that they have concluded a substitute transaction prior to avoidance when the CISG expressly says so. Our submission is that respondent is indeed exempt and claimant cannot be entitled to the damages they seek. Thank you.
Thank you, counsel. A quick question. Should the tribunal take anything from the fact that there was no formal notice of force majeure compliant with Clause 12?
Thank you, Madam Presiding Arbitrator. I believe you're referring to Clause 12.2, where the affected party should notify the other within 5 days. Our submission is that this notification did indeed happen. The event was on the 8th of February, and on the 10th of February, respondent and claimant did indeed meet, and in those circumstances, respondent informed claimant that it was impossible to obtain the permit in those circumstances.
So that was sufficient.
Indeed, we can note that in Clause 12.2, there was no need for written notice, no formalities attached.
Do you have any comment on that? Last minute question.
Madam Reed, the real force majeure event, meaning that respondent was actually prohibited from performing the contract, occurred on February 14th, when the Equatorianian authorities placed all permit applications on hold. All that happened on February 8th was that Equatoriana announced a revision of the practice, which caused respondent to scramble and immediately state that performance would be impossible. This only shows respondent's motives in these proceedings. Thank you.
Thank you. Do you have any further questions?
Probably one last question for Mr. Prager, a quick one. And I am referring to the letter of 1st March in R3. So in that letter, your client is saying that they will do a cover sale in the next days, but your client had already done the cover sale with herbal cosmetics. So either your client was lying or the sale for herbal cosmetics wasn't a cover sale.
Professor Munoz, there's actually a third option, and this is the option that is true in this case. 2 points in this regard. First, Ms. Theophrastus, who sent this email, is a legal layperson. And second, due to her recent history when contracting with respondent, she knew that the mere agreement for the sale of orchids does not mean that the orchids will be delivered and paid for. This was what Ms. Theophrastus was interested in. She was interested in delivery and reception of payment. On March 1st, the orchids were still with claimant, waiting to be delivered, in Ms. Theophrastus' eyes, sold to Herbal Cosmetics. This statement does not contradict the objective fact that the orchids meant for respondent were sold on the 15th of February. Thank you.
Counsel, in the calculation of the damages, you rely on Herbal Sale 1, correct? Let me refer you to Exhibit R3, which is the email from Ms. Theophrastus to Mr. Algius, containing the avoidance. And in this email, she informs respondent about the future intentions. If you look at the third paragraph, as indicated by Mr. Hamann, orchids will try to sell the vanilla orchids as soon as possible. So the impression is created that the cover sale will occur later. How do you reconcile this with your argument that the cover sale is in fact herbal sale 1, which occurred earlier?
Professor Elsing, as I understood it, this was the question posed to me, and as stated, Ms. Theophrasis was a legal layperson and was interested in the reality of the orchids, meaning were they delivered, were they paid for, and not do I have a sales agreement for these orchids. And the reason for that is that the last sales agreement for orchids she concluded was not performed by Respondent.
Perhaps we can hear the permission of Madam Chair, Respondent as well on this point.
Of course.
Thank you. In response to opposing counsel, the tribunal need only look at the final sentence of Respondent Exhibit R3. Once Orchids is able to quantify its damages, we will contact you again. As opposing counsel has conceded in its explanation of Article 75, all that is required to calculate damages under that provision is the price for that substitute transaction. Article 75 operates on that difference in price between the original contract and the new contract. But by this date, Claimant was already well aware of the price under the contract with Herbal Cosmetics, and therefore, by not stating that this was a substitute transaction, it's clear that Claimant itself did not think it was either.
Thank you. We must bring this hearing to an end. I can say that the parties have given this tribunal a difficult set of questions to answer, but that counsel for both sides have been of significant help. So thank you, counsel for Claimant and counsel for Respondent.
Thank you, ladies and gentlemen. I'm sure you'd all agree with me that it really was an excellent hearing. So again, thanks to the teams and to the panel. Ladies and gentlemen, as you can imagine with an event of this size, there are many logistical challenges. But together, we are about to embark upon the single largest logistical challenge. And there are about 2,000 people in this room at the moment, and we are all going to need to leave the room out through a certain set of doors, and then come back in after the tables have been reset and the service has been conducted, and we'll check your tickets. So I do need you to pay very close attention to how we're going to do that. As you look down the hall, to the left, there are doors open. Please exit by the doors that are to the left as you walk out. It'll take a little while for us to reset the room and fix things up, so don't worry. Take your time, go to the bathroom, do all those sort of things. Make sure you take everything with you. Do not leave anything in the hall. It's not possible to reserve seats. When you're outside and when you're coming back in, you will have to produce your ticket to re-enter the hall. The banquet is a ticketed event. Please definitely do not leave a jacket inside with a ticket inside, because then we've got a problem with both the jacket and the ticket. When you come back in, just before people leave, I need you to keep listening. When you come back in, we ask you to stay in here until such time as we've got everyone back in. Okay, so when you come back in, find a table and sit there and just wait until we get underway and everyone is back in. So please do things like go to the bathroom and the like during this time. It's really important that when you're coming back in, you do not run. Okay? Every year, we see people running in and potentially knocking over tables and so on. Don't do that, please. If I see people running, I might just send you out again. Okay? So it really is very important that we do take this sensibly and seriously, and that way we can get the banquet underway as quickly as possible as well. So with that, and a final thank you to the panel and the teams, the hearing is concluded. You may leave.